So I will deal with the issues relating to the death penalty generally. I think there have been a number of questions on substantive assistance, diminished responsibility test, and so on. I will deal with those issues. I think members who spoke agreed that the drug problem is a serious one. I think Mr. Lawrence Lien is opposed to it on principle. All the other MPs and NMPs who spoke agreed that the death penalty is appropriate to deal with the drugs problem. So in this House, we have near unanimous agreement on the death penalty, but some differences in how it should be applied. I think Ms. Sylvia Lim, Mr. Pritam Singh, Mr. Liang Enghua, and Professor Eugene Tan suggested more discretion to the courts on the application of the death penalty. That's well-intentioned. My own view is the starting position has to be that the courts should have discretion. That is eminently correct and sensible and right. Most of us will agree with that. And if you want to make a sentence mandatory, i.e. remove the discretion of the courts, there must be good reasons. How then should we approach the question of death penalty for serious drug offenses? If we focus only on the trafficker and ask if mercy ought to be shown, the answer is a no-brainer. Must be yes. No one can disagree with that. But that is not the only question, or even the primary question. The correct question has to look at the context and raise the following issues. One, what is the nature of the drug menace, the nature of the beast that we are dealing with? Two, what are the risks we face as a country, as a society, from this risk? How do we deal with these risks? What has to be our approach? What happens if we completely remove the mandatory death penalty and replace it with death penalty to be imposed at the discretion of the courts? Are we prepared for the trade-offs and the risks? I will emphasize this. The answer depends on the level of risks and cost to society that you're prepared to accept. And in assessing the risks, the context is this. Let me take you through some data. First, drug users globally has gone up from 180 million to 210 million in the last 10 years. Second, every year, and this is from the UN ODC World Drug Report 2011, somewhere between 100 to 263,000 people die due to drugs. Mean age of the deaths, mid-30s. We hardly ever hear tears shed in public for these 200,000 people who die. But we shed a lot of tears for everyone who is on the death row. Compassion is important, but context is also important. The fight worldwide against drugs is being lost. You can see what the UN Secretary General has said, slide 4, referring to the situation in Central America, in Afghanistan, and you have heard DPM Teo on how drugs flow here from Afghanistan, how many tons come to this region, West and Central Africa, threatening entire regions and governments and countries. The regional situation is also not pretty at all. In Malaysia, it's estimated there are 350,000 drug addicts, probably going on to about 500,000 by 2015. And those are sort of official figures. In Indonesia, we have probably about 1.3 million of 10 to 19-year-olds who have experimented with drugs, and slightly more than 500,000 people who are regular drug users. You've heard DPM Teo talk about the drug labs proliferating in the region. You know that drug syndicates are sophisticated multinational corporations, well-financed, international networks, very smart people at the helm, making huge profits, and with good access to people can act as couriers. We in Singapore, or Singapore as a whole, is a highly attractive destination. Rich, people can pay for drugs. It's a transport and tourist hub. 500,000 people come into Singapore every day, or 182 million every year. It's logical for Singapore to become a drug hub, or at least a major transshipment center. What is the impact of drugs in Singapore, even with all our tight laws? About 2/3 of the local prisoners are drug addicts, drug offenders. 80%, 8 out of every 10 in the prison population have drug antecedents, i.e. they may be in for something else, but they have drug antecedents. That's a normal trend worldwide, not in terms of percentages, but that those who get into drugs commit some other crime. Consider the impact on offenders, families, victims, society. Not many people in public shed tears for them. And the youth abusers in Singapore shows a worrying trend. You look at the trend. As DPMTO set out, we take a comprehensive set of measures against both supply and demand. Involves education, early intervention for young abusers, strict border controls, tough enforcement, tough drug rehab regime for first and second time of abusers, where they receive counseling and rehab, long-term imprisonment after the third time, and of course the CLTPA against syndicate members, where witnesses fear to testify, and tough punishment, caning, imprisonment, mandatory death penalty. The death penalty or the mandatory death penalty cannot be the only solution. It has got to be part of a comprehensive framework to deal with the situation. The consequence of our approach is that we are, frankly speaking, one of the few countries where the drug menace has been fought reasonably successfully. And I emphasize reasonably because this is not a fight you can say you have won. And you can easily lose it. Drug abusers have gone down since 1994. You see the slides when 1994 when we implemented even tougher regime. In the context of the global trend where you will see that graph going upwards, anything that doesn't go up is success, relatively speaking. But we must also admit that in maybe 2002, 2004, numbers were artificially depressed because of Subutex. So making allowance for that, nevertheless, it is a reasonably successful fight. Drug kingpins avoid Singapore. There's no substantive production here. Couriers think twice before they try their luck. They try to keep below the threshold for capital punishment. We know this through intelligence. As I said earlier, we are not a transshipment hub, despite our connectivity. Drug prices in Singapore, which is another market indicator, are comparatively high. Purity levels comparatively low, as you can see from that table comparing Singapore, Malaysia, and Hong Kong. Purity level at 4% compared with Hong Kong's 57%. Prices normalized $313 per gram compared with Hong Kong's $87. These are the differentials which people sometimes don't appreciate. So when you debate mandatory death penalty, when you make points for and against it, it's not an academic argument per se. You have to look at it in this context. Ask yourself, why do drug kingpins avoid Singapore? Why is it difficult to get people to traffic drugs into Singapore? Why is it that traffickers often and deliberately keep below the limits for capital punishment? Remove the mandatory death penalty, what will be the consequence? We are a lucrative target. Would there be more people willing to become couriers? Remember again, we are dealing with drug lords who are very smart people with lots of money, no scruples, and will mercilessly exploit everyone and every situation. And it's not difficult to get people in this region to become couriers. Lots of people who need money and lots of drug abusers who can be persuaded to become couriers. Not difficult. Our stance on death penalty is extremely well known. In Singapore, traffickers face capital punishment. That sends a message and reduces the number of couriers who are available. You remove that fear, you remove that penalty. Are we willing to take the risk of many more people becoming willing couriers? You've seen from the data, not just our neighboring countries, but the broader region, we have millions in the region who have the potential to be persuaded to take drugs into Singapore. I think a couple of MPs, I think Ms. Lim and Mr. Singh have cited Professor Woon's comments at a forum on death penalty. At the forum, Professor Woon made some remarks about the mandatory death penalty and how it warps discretion in a couple of ways. And both MPs referred to that. Professor Woon went on to describe the prosecution as having a heavy burden in determining the appropriate charge when a person is killed. I have specifically asked Professor Woon about his comments, and he has confirmed the following in writing. He was illustrating a general point about the responsibilities of the prosecution. He has always, and he emphasized this, he has always drawn a distinction between the exercise of prosecutorial discretion in drug cases from that in murder cases. He told me that he has stated this previously, publicly, in interviews and talks. His view is that for murder cases under Section 300, it is better that the courts have the discretion. For drug cases, Professor Woon's view is that the discretion is better placed with the public prosecutor for the following reasons. One, the assessment would have to be made on intelligence not within the knowledge of the court or often inadmissible in court. Two, the public prosecutor will be better placed to take note of broad public policy considerations. It is often the case that an accused is willing to plead guilty but will not do so if the charge carries the possibility of capital punishment, even if it is discretionary. Professor Woon did express himself in broad terms during the forum, and he did not specifically draw the distinction between drugs and homicide when making those comments. But he told me that his precise views are as he has set out to me, and that he has always held these views and continues to hold these views now. He confirms that he has expressed those views in public previously. And he emphasizes that his remarks at the forum were essentially directed on the question of murder provisions, not drugs, though he did not explicitly say so. Professor Woon, when he was Attorney General, had expressed similar views to me in the context of AG's discretion in dealing with drug cases. This is a topic on which we have had several discussions because, as I have said in the House before, both Home Affairs and Law review these issues constantly, and the courts and the AG are people we consult with regularly on these issues. And likewise, the current Attorney General, the current Chief Justice, also takes similar views. In the context of drugs, the suggestion to give discretion to judges looks attractive at first sight, because the approach is maintain the death penalty for deterrence and allow for mercy in individual cases. As I've said earlier, this is something that has concerned us deeply because, like members, our preference would be, in most cases, all cases, to give more discretion to the courts. But we have looked at this carefully, discussed it with the agencies, the Attorney Generals. We have also discussed it with both Chief Justices Chan Sek-Yong and Sundaresh Menon. And you have to see whether it is doable. Is it possible to give more discretion? Is it practical? The views of both CJs Chan Sek-Yong and Sundaresh Menon was that if you want to give more discretion to the courts, and if Parliament deems it necessary to make a drug offence punishable with the death penalty, it is preferable that the statute sets out as clearly as possible the circumstances under which the death penalty ought to be imposed. You can understand them saying that. And they've also said, while the courts will of course exercise any discretion in a principled and consistent manner, their view is that it is best that the legislature define in the clearest possible terms when the ultimate punishment is justified. That is the responsibility of the legislature, which is elected by the people. So let us take it from there. Members can understand why they have asked for this and why they say that should be the framework. Think it through. How will we craft a legislative provision to give more discretion to the courts? First, the quantum, 15 grams of diamorphine. Do we agree that this is a serious threshold, or do we say that it should be some other threshold? Once you agree on the threshold, and if the elements of the offence are made out, i.e. trafficking over 15 grams, then how would you have the court exercise discretion? On what basis? I'll be happy to hear from members at the end of my speech if they have views. But can we conceive of a discretionary sentencing approach which maintains the deterrent value of the death penalty across the whole spectrum of drug trafficking activities? With the best will in the world, I suggest it will be difficult, if not impossible. That is the view we came to after discussing this extensively with, as I've said, the agencies, the Attorney Generals, the courts. Consider what factors you will set out for exercise of discretion. Age, would you say youth? Would you say young mothers? Would you say impecuniosity? Would you say the trafficker was baited with love? Would you look at other family circumstances? Set out the criteria, and I promise you that drug lords will design the couriers in accordance with the criteria you have set out. And they will send you as many couriers as you wish, fitting that criteria. That's because you are looking at background factors and the manner in which the crime is committed becomes less important. Trafficking is the crime. So while it is attractive in broad terms to talk about giving discretion, look at it in detail and see whether it is workable. How would it work? In murder, yes, you can look at it case by case. You can look at it to see whether it's a crime of passion. You can look at the individuals. How would you do it for drug trafficking? how would you do it in a way that doesn't affect the fundamental deterrent effect of the death penalty? So let us be very clear. You go down this route, in effect, you will have de facto abolition of the death penalty. So be realistic and then pose the question in realistic terms. Do you want de facto or at least substantial reduction in the deterrent value of the death penalty? I'm not arguing that you cannot put that position forward, but at least then that will be a more clear, hard-headed approach which analyzes the real issue. On the one hand, the drug situation, the risks that we face, and on the other hand, a de facto abolition. You weigh the risks, you decide. The Professor Woon at the same forum also said that judges very seldom go for the maximum. I quote, "In this, they are like university lecturers who never give you the maximum marks. They sort of hover around the center. There is a tariff for most cases. So you know what will happen." Professor Woon has set it out. We all know what will happen. A, the drug lords will send you couriers who fit whatever criteria you set out. And B, there would be understandably a natural reluctance to impose the death penalty. So let's accept it that it will amount to de facto abolition. And let's then debate it on those terms. And in those terms, then, the question for members is this a risk that you are prepared to take in the context of the global and regional situation and remove a key strategy in our fight against drugs? And on couriers, there are many misconceptions. Let us be clear. They do this for money. They know what they're doing is wrong. They hide the drugs in secret compartments and try and traffic through our checkpoints. As DPM2 has said and will say later, 15 grams is not a small amount. 2,200 straws to be able to feed 300 abusers for a week. Let me now move on to cooperation, the question that has been raised by a number of members. On the first exception, that couriers who have substantively assisted CNB in disrupting drug trafficking activities could be spared capital punishment. In looking at this, if the question was, and again looking at the speeches, it seems to me that members may have asked themselves the question, what can we do to help couriers avoid capital punishment? If that was a question, we don't need to make these amendments. The solutions are very easy. The issue is not what can we do to help couriers avoid capital punishment. It is what can we do to enhance the effectiveness of the act in a non-capricious and fair way without affecting our underlying fight against drugs. Discretionary sentencing for those who offer substantive assistance is the approach we have taken. For those who cannot offer substantive assistance, then the position is as it is now. Some members have asked, would it be better to say the courier has done his best, that he acted in good faith? I think Mr. Edwin Tong, Mr. Alvin Yeo, Professor Eugene Tan, Mr. Lawrence Lien, Mrs. Cham, I think Ms. Faiza Jamal made these points. The short answer is it's not a realistic option, because every courier, once he is primed, will seem to cooperate. Remember, we are dealing not with an offense on the spur of the moment. We are dealing with an offense with a criminal organization on the other side that doesn't play by any rules, and which will look at what you need and will send you what you need. So, if you say cooperate, your couriers will be primed with beautiful stories, most of which would be unverifiable, but on the face of it, they've cooperated. And the death penalty will then not be imposed, and you know what will happen to the deterrent value. Operational effectiveness will not be enhanced. Will we be better off? Will we be worse off? As I started out, in these things, it's not as if there is one clear answer one way or the other. It is what we in this House consider to be important for our society and weighing the different approaches. If we believe that couriers, even if they tell us stories, ought to go free, then that's a choice we make. But make that choice, but don't fool yourself that there are no trade-offs. Mr. Edwin Tong, Professor Eugene Tan, Mr. Desmond Lee said, are drug couriers in a position to provide substantive assistance? Fair point. It's a point that was raised extensively during our consultations. Let me throw back the question. Assume the couriers are not able to help. What should be the penalty? That goes back to the fundamental question. Should there be death penalty for couriers? That is a question you have to cross. It is a difficult question, but if you answer that question, and all members have agreed that there should be death penalty for couriers, except Mr. Lin, once you say yes to that, then you will see this change as making an exception to that position. So only those who qualify for that exception must be spared the death penalty. You then need to be careful about making the exception so wide that the rule itself becomes meaningless. In any event, CNB's operational assessment is that couriers can give substantive assistance in some cases. Also, the very existence of the mechanism adds friction to the entire drug trafficking network. Every arrested courier is now potentially a lead back to the syndicate. That will make it difficult for the entire organization. That's not to say, let's not underestimate the syndicates. They will, of course, try and work around this in innovative ways. The question for this House is, should we therefore not try this approach? Mr. Desmond Lee asked, can we recognize substantive assistance in other areas of law enforcement? Substantive assistance by couriers is especially useful in the context of drug trafficking because of their links back to the syndicate. By contrast, couriers are not uniquely or especially able to assist on combating on drug consumption and so on. Next, on the issues of who decides cooperation and by what criteria. The bill proposes for the public prosecutor to assess whether the courier has substantively assisted CNB. I think Ms. Sylvia Lim, Mr. Singh, Mrs. Cham, Ms. Faiza Jamal had concerns, issues of life and death. Discretion should lie with the courts to decide on cooperation. First, the cooperation mechanism is not novel, nor is it unusual. Other jurisdictions, like the US and the UK, have similar provisions operated by prosecutors to recognize cooperation for the purposes of sentencing. For example, Title 18, Section 3553E of the US Code, and I quote, limited authority to impose sentence below a statutory minimum. Upon motion of the government, the court shall have the authority to impose a sentence below a level established by statute as a minimum sentence so as to reflect a defendant's substantial assistance in the investigation or prosecution of another person who has committed an offense. Such sentence shall be imposed in accordance with the guidelines and policy statements issued by the Sentencing Commission pursuant to Section 994 of Title 28 U.S. Code. The courts decide questions of guilt and culpability. Operational value of assistance provided by the accused, the public prosecutor is better placed to decide. The public prosecutor is independent and at the same time works closely with law enforcement agencies has a good understanding of operational concerns. An additional important consideration is protecting the confidentiality of operational information. The very phrase substantive assistance is an operational question and turns on the operational parameters and demands of each case. And there is a concern within the agencies that too precise a definition may limit and hamper the operational latitude of the public prosecutor as well as the CNB. And it may also discourage couriers from offering useful assistance which falls outside of the statutory definition. Ms. Lim suggested why not, if there are worried concerns about confidentiality, have it, I think, in camera, though I'm not sure she used that phrase. The real point is this. Over many cases, just imagine the scenario. In case after case, the defendant argues that they've rendered substantial assistance and that it's either the fault of the CNB in not dismantling some organization overseas or not. And all of that can then become the subject of cross-examination. CNB officers take the stand. Their sources of information will have to be disclosed, what they did or didn't do within Singapore, outside of Singapore, with intelligence agencies, what they attempted to do to try and dismantle. All of that will come out in court, case after case. Ask yourself whether that's the best way of dealing with this question. Is that helpful, or does it hurt our broader efforts? Again, is there a risk? Obviously, when you give such powers, there is a risk. But which is a bigger risk? This is what you have to ask yourself. And over a period of time, if the entire modus operandi of the CNB is then in the public domain effectively, even if it is in camera, does that do us good? Ms. Slim, Mr. Singh, Mrs. Cham, Ms. Jamal, I think raised or implied the possibility of abuse, or at any rate that the public prosecutor may refuse to issue a certificate when substantive assistance has indeed been provided. As I said earlier, I accept that the risk identified, of course, exists. What we have to assess is overall, are we better off if we reduce this risk and the issue is transferred to the courts? That's a judgment call that has to be made. Is society better off? Which route has greater risks? And also take into account, when you consider the risk of abuse, that the public prosecutor is not exercising an unfettered discretion, subject to judicial review, either on bad faith or malice, which is expressly provided, and of course unconstitutionality, which goes without saying. Significant institutional incentive for the public prosecutor to exercise his discretion properly. Over time, if the public prosecutor consistently recognizes cases where substantive assistance has been provided, that will obviously encourage more cooperation by couriers. On the other hand, if the public prosecutor acts capriciously or inconsistently, the system cannot work. So over and above the judicial check, it is really in the public prosecutor's interest to operate the system with integrity. This is not just the position in Singapore. I mentioned the US position earlier. Section 3553E's constitutionality has been upheld by a number of federal courts of appeals. And in the case of US and Huerta 1989, the court had this to say, and I quote, "We believe that whether a defendant's cooperation has risen to the level of, quote, substantial assistance, close quote, to the government is self-evidently, and I emphasize self-evidently, a question that the prosecution is uniquely fit to resolve. Nor do we perceive any danger of misuse of this power. There are significant institutional incentives for the prosecution to exercise sound judgment and to act in good faith in deciding whether to make Section 3553E motion. The government has an interest in encouraging defendants to cooperate with law enforcement efforts. The reasonable use of substantial assistance motions for those who cooperate will make others more likely to do so in the future. Close quotes. Let me now move to the question of false information. Mr. Desmond Lee questioned whether couriers may give false information to implicate others. That's one of the reasons why we say the assistance given must be substantive. Any information given will not be used against others unless the public prosecutor and CNB are, of course, satisfied as to its reliability. Associate Professor Eugene Tan asked, does the mechanism create a risk of self-incrimination? There is that risk. But let me throw back the question. What does that mean? Should we not have this exception because there is that risk? If we believe that the death penalty ought to be abolished, then I can understand Professor Tan's argument. But if that is not argued, and he is not arguing that, then you have to weigh between sticking to the current position, where if you prove the actus reus and the mens rea, 15 grams trafficking, the person faces capital punishment, and creating an exception where if he comes clean, he is given an option to come clean, and if he comes clean, he avoids the death penalty. Should you not give him that option? I think Professor Tan also made the point, would the CNB officers pressure accused to incriminate themselves? But that really raises questions outside of the purview of the issues we are discussing with today, as to whether we should or should not have such an exception. So really the accused, if he knows something, has got to decide between trying to run a false defense that he knows nothing and telling the truth. And I don't think members will argue against giving an incentive for someone to tell the truth, to help us and help himself. Ms. Sylvia Lim and Mr. Desmond Lee asked whether those on the death row will be given a chance to offer substantive assistance. The answer is yes. PP will assess, public prosecutor will assess what is to be done in consultation with the CNB. On the second exception on diminished responsibility, some members spoke on this. The law in this area has recently been set out by the Court of Appeal in the 2011 case of Ong Pang Siu. And our view is that the law has been set out. Genuine cases of mental disability are recognized. Judgments have to be made depending on the facts. And while genuine cases of mental disability would afford a defense, errors of judgment will not afford a defense. And the law is also capable of taking into account the progress of medical science in understanding mental conditions. Mr. Christopher D. Souza said law has to be interpreted strictly in its application to drug trafficking. It is a highly purposive and coordinated activity. Legal principles remain the same, however, in assessing whether diminished responsibility is made out. Ms. Jamal and Ms. Lim asked how will low IQ be dealt with, and Ms. Lim asked whether we can broaden the defense such that an accused without a psychiatric condition can still be, or an accused who doesn't qualify for the strict definition of diminished responsibility, but who is still vulnerable enough to be exploited. I think that is the context. I think sufficiently low IQ will constitute an abnormality of mind. As to what level of IQ is sufficiently low, cases have focused on the mental retardation threshold. Whether medical science will move further and whether courts will accept that, I think that's really not something that I want to preempt the development of. Our basic position is that there should be a partial defense for those who suffer from a mental condition which substantially impairs their responsibility. And of course, the public prosecutor retains a discretion in borderline cases.
Order. Minister, allow us to extend time under the standing orders.
Mr. Speaker, may I ask a concern, General assent of members present to move that the proceedings on the item under discussion be exempted from the provision of Standing Order 48.8 to remove the time limit to enable the Minister of Law and the Deputy Prime Minister to reply to all points raised by members.
I give my consent. Does the Leader of the House have the general assent of the honourable members present so to move? Leader, please.
Mr. Speaker, sir, I beg to move that the proceedings on the item under discussion be exempted from the provision orders of Standing Order 48.8 in respect of the reply to be made by the Minister and the Deputy Prime Minister.
The question is that the proceedings on the item under discussion be exempted from the provisions of Standing Order number 48.8 in respect of the reply to be made by the Minister for Law and the Deputy Prime Minister. As many as have that opinion say aye. Those against say no. I think the ayes have it. The ayes have it. Minister, please carry on.
It is not our intention to those who do not suffer from a recognized and proven psychiatric condition. So let me conclude by making some broader points. I have spoken several times about weighing the consequences in real terms before deciding what we do. Let's look at the situation with some real cases as to what we mean and what I mean. First, the case of Noi Noi. If you look at the slide, in 2006, Mohammad Johari was charged for the murder of his 2-year-old stepdaughter, Noi Noi. Her photograph was all over the newspapers. He admitted to slapping her, immersing her in water repeatedly. He was a father at 17, a marijuana smoker, cough syrup abuser, immature, deficient parent. He said he sometimes brought Noi Noi home with him as he thought that she would help him avoid detection by CNB. The real question, he is a victim, she is a victim of the drug traffickers and the drug lords. The question for this House is, how many Noi Nois do you want? Each trafficker potentially destroys several Noi Nois. If you look at Tony, age 51, long history of drug abuse, first admitted to DRC at the age of 16, 8 subsequent admissions, living with his mother who had to take a protection order against him, later imprisoned for drug trafficking and causing grievous hurt, beat up his father who committed suicide, picked up for vagrancy in 2010, now living in a welfare home, typical of the many cases that we deal with. Look at Nellie and Rose. Nellie, aged 6, placed under foster care after her mother, uncle and grandfather were arrested for drug consumption. She had been cared for by multiple caregivers and witnessed her mother's taking drugs. Her sister Rose, a newborn baby, was placed under foster care in 2010. If you look at Ricky, 9 years old, referred to MCYS in 2007, when his mother and stepfather were imprisoned for drug offenses. Both had a long history of drug abuse. Father was also a drug abuser. Ricky was admitted to a children's home where he was observed to have emotional issues, suicidal tendencies. His father was released but has now defaulted on his urine tests. Last case I wanted to highlight. Girl, we call her A, was arrested at the age of 16 for possession of meth. Drugs were given to her by her half-sister, now serving sentence for drug consumption, also her mother's boyfriend. Later, when her mother's boyfriend was incarcerated, she turned to her mother who gave her heroin regularly. She has 3 half-brothers currently incarcerated for drug consumption. 5 others arrested for consumption of drugs, friends of girl A's mother, consumed drugs at her half-sister's residence. Total number of people involved in this group, 12. We do need to show mercy and compassion to the traffickers, but at the same time, we also need to show mercy and compassion to the Noi Nois and the Roses and the Nellies and the Rickies of this world, and thousands of others like them. Young lives destroyed. None of us really are there cheering for the death penalty or mandatory death penalty. It has to be a careful calibration of the risks that society faces and the punishment that can be imposed. And if we go in any particular route, let's do it without hiding the truth from ourselves or by assuming that nothing else will change while we change certain penalties. Accept that if you change the penalties, there will be consequences. Ask yourself whether we are prepared for the consequences, and if we honestly are prepared for the consequences, then we change. I would suggest, ask whether the changes we make, are they going to help the victims or are they going to hurt the victims? And firmness, clarity of purpose, and compassion to both the offenders as well as the victims. Thank you, sir.